Thank you for taking time out of your schedules to join us. Our first question, we're going to start with Cheryl and just go down the line. Why have you decided to run for, re-election or run for this particular seat at this particular time?
Well, this is going to be my fourth election for running for re-election, my fourth campaign, and I'm proud to be the first full-blooded Asian American to be elected to district court in the state of Nevada's history, and I am proud to represent the Asian community as the only full-blooded Asian judge in district court, first sitting in family court, and still the only one sitting in family court, Department I.
Okay. Art.
I became interested in the family court soon after it was created. In fact, the family court's origination was somewhat controversial in the 90s. I was part of the study of the family court and some reforms that were made. And when there were vacancies at the end of the 90s, I applied for vacancies and was recommended to the family court in 1998 and 1999. I was elected after being appointed by Governor Kenny Gwynn in 1999 to 2000, 2002, and 2008. The same reasons for running in the late 90s for this job exist today. Having a strong court that actively manages its cases, that makes sure that the fundamental rights that the court addresses, some of the oldest fundamental rights that our families share, are properly addressed. All of the challenges of the court remain. Our community is probably twice the size as it was in the early 1990s. I have, in an arc of sorts, I started out as a team member coming into a court of 8 judges. We have 20 judges now. During the course of the last 14 years, I've been the chief judge of the entire court, the presiding judge of the family division, president of the District Judges Association. I've worked in legislative sessions concerning reforms for the courts that have expanded the family division to 20 judges. I'm not in court management now. For the last 3 or 4 years, I have assisted the court as necessary when we needed to review dependency like I'm doing now, but I'm managing the full caseload. The fundamentals of preparing for each case to make sure that you issue decisions in a fair and reasonable manner, and then enforcing those orders are the fundamentals that I think any judge should have. And I'm seeking retention in this job because I feel that I can continue to do an excellent job in that regard. There are a lot of measures of success for a judge. One measure of success is how lawyers rate the judge. In 2000, the first peer review for members of the bar, I had a 93% retention level. The most recent one last year, I had an 85% retention level. I'm not saying that's the only measure of qualifications or success, but it shows a pattern or a balance of work for 14 years in which I've done a good job, and I would hope that my experience would warrant retention.
Okay. Keith, why have you decided to run for this particular race at this particular time?
Well, I've been practicing family law for 21 years. I'm an AV rated attorney, which is the highest rating you can get. I have been the best attorneys in America since 2008. I'm a Mountain State super attorney. Those are all independent peer review rating that rate my abilities. I decided to run at this time because Ritchie and I fundamentally differ on illegal drugs and the effect that they have on families. I have appeared in front of them. The child is now 18, so it's an open case, so it's not an active case in front of the court, where Judge Ritchie on the record said illegal drugs were okay. He said that pot was no longer considered a gateway drug. All those things I know are not true because of my background before I went to law school as an ambulance attendant. And I watched the effect of those type of decisions destroy lives. And I think the primary role of a family court judge is to protect our children. I mean, you've got to divide property, you've got to divorce people, but if they don't have, that's a pretty simple issue if they don't have children. And if you don't have a fundamental understanding of drugs and the effect on the body and the effect on families, I don't believe today you should be a setting court judge, and that's why I ran against Ritchie.
We have Art brought up the fact that the only real metric we have to measure the judges is the RJs, well, for the civilians I should say, is the RJs judging the judges poll every 2 years. What ideas do you have to make the poll or the survey perhaps more accurate or more appropriate for civilians, for lack of a better term, to use when determining whether a judge is up to snuff or holding their own on the bench? How can we improve it?
You know, I guess one of the issues with that is they say that it's confidential. I personally have not filled one out in years because I don't believe they are confidential. And I believe that when you are blunt as to your opinion of certain judges, that there is a method for the judge to figure out who it is. And that may be naive on my part, but I don't believe it is. And as a result, I'm not convinced of the confidentiality of it. So I know myself and other attorneys, they simply won't fill it out.
Do you have any ideas how we can improve that process? I don't know. Well,
I think the only way is to ensure confidentiality, which I don't believe is done when the RJ is running it.
Cheryl, next.
Yes, I've got lower numbers than Art Ritchie on the retention rate as far as the surveys that have been done before. But I don't think, and I agree with his statement that I don't think it's a reflection or a measurement of how well we're doing on the bench. First of all, I have completing my 14th year on the bench and having run 3 contested elections. As far as the work I've done, my appeal rate is very low. Haven't had any crazy decisions that have ended up in the newspaper over the years. And I've handled thousands of cases. As far as the attorneys that fill them out, I think there are some attorneys that have a good opinion of me, but I don't think they bother to fill out the surveys. So statistic-wise, we might not be a good measurement. Maybe there are attorneys that don't have a problem with you, so they don't bother filling out the survey. And then there are the ones that maybe they have grief with you, so then they actively fill out the survey. So there's different philosophies, but as far as improvement, maybe they can give some type of incentives to the attorneys, that maybe give them credit for filling them out or making them mandatory. So, but each of the attorneys that fill out the surveys, they have to actually practice in your courtroom. So there's no way of verifying that. They might just be hearing it from another buddy of theirs, and then they're just filling it out or being told how to fill it out. So the accuracy, I think, needs to be improved upon, and maybe they can take a look at that.
And before we go to Art, I apologize, I haven't mentioned this yet for this particular race. This is more for you, Keith. I have no active cases in front of Art. I have no active case in front of Cheryl. I can't remember the last time I was in front of you, Art, quite candidly. I know you did a settlement conference I was involved with a settlement conference with you literally a decade ago with Paul Lemke. And I think that was the last time we had any interaction. And Cheryl, it's been years. If that does change, if in the next few weeks before we do our endorsements, our deliberation on our endorsements, Keith, and somehow I do end up with a case and it is in front of Art, I certainly will not participate in the deliberation process. But I'm down in family court so infrequently that I, knock on wood, I don't foresee that being a problem between now and a month from now. So I'm sorry to derail us, but I just wanted to make that disclosure.
I agree 100% and said this when I was an administrator in the court, that the RJ survey is not the only measure of performance. In fact, it feels even uncomfortable me touting it because the sample size is pretty small, and it is anonymous. And I don't know, I've never heard any one of my colleagues suggesting that there was any notice. I mean, the RJ has an antagonistic relationship with the courts. They're not going to provide or share the identities of those folks. But we're in the middle of the best measure of performance for a judge. We're in the middle of an election. And during that election, folks like you, folks like fire, folks like police, folks by central labor, those folks interview people and offer endorsements. After 14 or 15 years on the bench, thousands of people have appeared in front of me. Those folks work for unions, they work in different walks of life. I've been blessed with endorsements throughout my career, and this year is no different. Police Protective Association, Central Labor Council, the Fire Department. Those are measures of performance. I assure you that an incumbent judge may have trouble getting those endorsements if they're not performing properly. And so the RG survey is simply consistent with the other endorsements that folks have had over the years. I do think that there is a potential, and judges have been concerned about manipulation. For example, let's say that you have 150 responders to a survey. 10 or 15 folks who got together who responded collectively to give negative reports on retention could skew those results upwards or downwards, 8, 9, 10%. And the difference between getting an 85% rate or a 65% retention rate might only be a handful of lawyers in the family division. And different judges get different folks who respond to them. So, I think that there are measures of performance that are better than the RJ survey. I know they love their survey. I think that you probably could name some judges who are scoring low on that survey who are fine judges, and you might be able to, it's a fair comment to say that you might have judges who score highly who aren't doing a great job. So I don't, to improve it would require a more comprehensive review of the work that you're doing. I mean, the Supreme Court has talked about reviewing the actual data for how many cases you move, how many cases you have on backlog. I mean, we've established a report in real time so the judges can be evaluated on their performance of how many cases. This is something I believe in very, very strongly, the accountability of courts and making sure that they know every case that they have on their docket. Why aren't they in compliance if they aren't in compliance, and making sure that you move those cases and hear those cases in a timely manner.
Freddie, do you have a question? Because you've asked it questions a couple times.
No.
So I'm just trying to open the door for you.
Yeah. If a family represents themselves in court, a couple of questions. Will they get a better benefit without a lawyer representing them? I mean, meaning they could express their thing directly to you, and they will get a judgment directly from you, rather than having an opposing opinions from, if they're represented by a lawyer.
Maybe a broader way to, I guess we'll start.
Our views on pro-pers.
Yeah, our views on pro-pers in general, maybe how to help improve that process, or what difference does it make, if any. And who do you want to answer first? Your choice, Freddie.
Well, I guess mostly the incumbent.
Well, but even then, Keith does have perspectives
yeah.
as well, because I'm sure.
Yeah.
And the reason I'm just saying this is I've gone up against pro-pers, and there are always difficulties, and I'm sure Keith has been in on that side of the fence as well. So they all have unique viewpoints.
Well, that's fine. If you'd like to start
So,
with art, I have no issue with that.
It doesn't matter.
Yeah.
It's a huge challenge. More than 50% of folks in family division especially are unrepresented, one side or the other. Obviously, if everyone could be represented, then you would have both sides with an advocate who knows the law and the facts and can properly present. But a judge is responsible for making sure we have a fair hearing, and so there's this tension or balance between making sure that the hearing complies with the rules that need to be followed and making sure that the outcome is appropriate. We created a self-help center, and our court website has access to forms that unrepresented folks can use to navigate the legal system. Cheryl and I and the other judges just supported a wholesale change in which Legal Aid of Southern Nevada took over our self-help center. They do seminars every week. We have a website product that explains each step of the legal process. In fact, you were even on that, weren't you? So the courts are trying to do community outreach to help folks. I think that it's strictly an economic consideration most of the time. I think most folks would like a skilled lawyer like Keith Lyons, or when I was a lawyer myself, representing them rather than going into an environment that's different without knowing all of the laws and all of the procedure. But so will someone get a better shake if they go in a proper person? Gosh, I don't. That's not been my experience, but I think that the courts are very careful to make sure that there isn't any bias for or against folks who are represented or unrepresented. Usually the objection or the complaints that I've been hearing are on the other side, folks who invest and hire a lawyer, and they feel that proper person litigants are allowed to cut corners or not present information in a proper way, and the courts can't have that either. So it's a matter of education and a matter of having time to have a hearing with these folks to go over that with them.
So you would say it will be a longer process?
Well, we have rules in place that allow us to bring folks in early in the case. And in that case, the court explains what's going to happen. These are the various options that we have. This is how we can adjust the case, and your case may settle by mediation. Your case may settle by a conference with a senior judge. Your case may need to go to trial. and you answer the questions. This case management conference is supposed to happen within 90 days of a domestic case, a civil domestic case. And at that time, when I have unrepresented folks, I try to learn, what do you want, what are the barriers to a resolution, and how do we get there? And it all depends. Every case is different. Some have children and have to work through custody issues. Some are just property and debt issues. Some of them are, can be resolved very quickly just by identifying those issues. But the key here is access. Filing and getting in front of a forum that can decide your case. That's why having a quick or speedy opportunity to be in front of a judge is the key piece of that.
I do have a comment.
Well, everyone else has to answer. Is it dovetailing with that question, or is it something different?
Just a comment.
Yes.
Okay.
Personally, I have been through the Las Vegas family court system, and I did represent myself. And I do have to say that our court is very fair, and is someone that can rely on the court. Absolutely, that's our family court here, compared to anywhere else that I've known of.
Well, I'm
So,
glad to hear that.
yeah.
I got to be honest, I've heard from other folks who maybe didn't have the best experience
It's
in
the
court.
opposite.
Yeah.
Okay. Well, Keith, what are your experiences with
Well,
pro pers?
this is where the problem comes in. And with a significant percentage of pro pers in Las Vegas, you're dealing with two issues. One, you're dealing potentially with language barriers. And two, you're dealing with financial issues because they can't afford to hire an attorney. And what ends up happening is typically when they go to court as a pro per, they're still required to follow the court rules. So if the other side has an attorney, then that other side has a very significant advantage. And there are things that people in proper person just want to bring to the court because they know certain things have gone on, but they don't know how to either bring proper evidence in that's admissible to the court or even how to explain to the court what they're trying to do. And as a result, the attorneys object and the courts don't get the full color of what's going on in the case because there is a lawyer. While courts are to look at the merits of the case and try to decide things in a fair and equitable manner, they still have to base it on admissible evidence. And too many people in proper person don't know how to get crucial evidence in. And when that happens, there is a miscarriage of justice. In all honesty, you can't blame the judge, although that sometimes is done, because the judge has particular rules that they must follow. Violating those rules, those evidentiary rules or type of things, is what they know will get them overturned on appeal. It's one of those black and white issues. Well, sometimes not so black and white, but most of the time those are black and white. And so there is a distinct advantage to having an attorney. But unfortunately, too many times it comes down to pure, unadulterated finances. And if the people don't have the money and the pro bono project is overwhelmed where attorneys represent people for free, then you hope that both parties come in unrepresented because at least then they're theoretically on an even playing field. But if there's an attorney involved against someone unrepresented, typically the person unrepresented is not going to be happy with the outcome.
And Cheryl, Art had said you were involved in.
I have a few thoughts on that. My main thought on that was, first of all, I think it takes years of experience to acquire skills as a judge to speak to these pro pers in a humanistic standpoint so that you can somehow make a connection with them. Because number one, when they don't go in with an attorney, especially ones, that are of minority status, they're very extremely nervous. And in the Asian culture, they have a lot of respect for authority, and sometimes they're nervous when they come into court. So you have to talk to them. You get the other extreme. Sometimes I get a Filipino couple, which is kind of rare. They come in and they're like, I'd rather give all my money to somebody else than to give you money, and they fight about that, a little bit of drama. But I think that it takes skills to calm them down and then get them to think rationally about what this impacts either on their young children, and explaining to them. Sometimes I have my usual speeches like, the way you're treating each other now, when your kids grow up to have their husbands and wives and future spouses, how do you think they're going to treat them the way maybe you're treating them now? And if you keep repeating this pattern or behavior, it may pose problems for your children in the future as they grow into and mature into adulthood. Now, does that when I have a pro per and I have an attorney, I have a lot more respect for attorneys who fall into the category that they understand what the other side is going through, but they don't go cutthroat on them, like they just want to do a motion and eliminate, exclude all of the evidence, no, you can't bring anything in. There's some that they understand and they're good at like talking to the judge and just saying, well, just mind you, if there are alternative sanctions available because they didn't comply with the rules. There was a recent Supreme Court case, Blanco, says that you can't completely default them or cut them out in the trial. Parents in custody cases are the main witnesses. If they're not allowed to bring their own witnesses, sometimes we have to follow the rules also, but I always think the parents are the main witnesses. We could still get information out from them, or I can say, well, we talked about the grandmother before, so we knew she was going to be a witness at trial. Maybe they inadvertently didn't list them as a witness, and if the other side had a due process notice and knowledge of it, I'd say, no, we'll bring the grandmother in for the trial. You knew that she's a main player in this case. A lot of times they mess up on the evidence. They didn't bring in completely their bank statements or tax returns. But we work on that. And ultimately, judges have a standard of acting and making decisions in the best interest of the children. So our job is to protect the children. Not so much what mom wants, what dad wants, but getting to the truth, getting to really what's going on, the dynamics of the family. And that takes skills over the years to acquire, like where you think this mom's coming from, this dad's coming from. What are their motivations, why they did do certain things in the past, or why they're taking a certain position in the case. And so, as far as pro pers, and again, I did a YouTube video. We're on the website on that. And technology as well would assist. It's so much easier now for them to, and I think the attorneys hate that they can just do their own self-help forms and get through the process. But patience, it takes a lot of patience to tell, somebody, well, next time you need to file an opposition, we'll let you off with a warning. But if you keep repeated behavior on that, now, I think, Kevin, you said you had a positive experience, because I think you're highly, educated and you understand the process. There are some that are either too scared or some that are just too mean to the other side, that they don't care, that if they don't get their way, then they're not seeing straight through the process. Those are the tough ones to get through. The ones you get nods from their head and you're explaining to them, then they understand how you can maybe get them to a quicker resolution, by talking to them about the impact on their children or their finances.
In actuality, it is specifically family court that I was referred to. On top of it is that the judge that was sitting was experienced. One with the attorney tried to smear you, try to do all kind of things, try to attack your character, etc. But the judge have so much experience, and they see through that, and that's what's going to make difference. And the way that's ruled and etc. is not damaging to the other party, but yet it's remain, because in the long run, it is still family. There's kids involved, etc. And that I think that's so important. Unlike property argument, money, finances, those type of things is totally different.
You are correct, but one of the things, in order to do family law for as long as I've done it, if you can only see your side of the case, i.e. you're representing the husband, so all you see is the man's side, or i.e. you're representing the woman, so all you see is the woman's side. If that's all you see and you can't understand that there's also this coming together, you can't be effective as a family law attorney. Because quite frankly, if you're that one-sided when you appear in court, the judge is going to do what he or she believes is in the best interest of the child, and that isn't generally going to be just one-sided.
Absolutely.
And
that's why
the
there
issue.
are
That's
so many attorneys that is lopsided,
And-
so-called.
And
And the judge comes in as the, we'll call it protectors, because they have the experience and understand and make a judgment on it. And that's where the positive thing that I said. So it makes a lot of
difference.
difference.
We're not quick to judge. Because sometimes people make an outrage in the courtroom, and then next time they're actually sitting in the trial, you find out they're not really bad people, not bad parents. Maybe they just come into court first time because they always feel like they need to fight with the other side. So never judge a book by its cover. give them a chance, have a lot of patience, and just say, maybe, yeah, okay, I don't know, I'm not going to get first impressions with you. I had that happen. I had a dad, and he was a real jerk in the courtroom, and the first time, and I was like, whoa, who's this guy? And then he took the stand, and he loved his kids. He was good. He testified. He took care of his kids. He was good with them, and I think that that made an impression on me. So I think that's
Experience,
a good judge
yeah.
will not prejudge things. You're not supposed to prejudge things.
Well,
So at least you will take a proactive approach, that listening to the party that has no representation, not knowing proper court proceeding and lacking all these things. At least you would look into that and not just one-sided because the
We
other
can't
party
talk
is
the
not
lawyer talk with them, like we can talk
represented.
with like Keith in the courtroom. We could talk the lawyer talk, explain the rules, and Rule 54, Rule 4. They don't know, so you
Right.
have to change your your tone and tell them, well, you need to do this, do that. But please understand, we're not your lawyers. We can't give you legal advice. If you want help, go to this
Absolutely.
resource, go to that resource.